Good morning, ladies and gentlemen of the listening and viewing public. Good morning, members of the media. Thank you for joining us today for this Ministry of Education, Employment and Gender Affairs press conference. My name is Kristen Saku. I'm the Acting Chief Officer for the Ministry of Education. With me today, I have the Honourable Minister, Ms. Tara Rivers, and I have the Director of Labour and Pensions, Mr. Mari Ebanks. We're also joined by some of Mr. Ebanks' technical team, Ms. Laval Linwood, the Deputy Director of Labour, and Mr. Gene Hydes, the Head of Inspections, as well as Ms. Tammy Ebanks, who is the Acting Deputy Chief Officer in the Ministry with responsibility for Labour, and Ms. Kim Kernel, who is a Policy Analyst in that section. This press conference launches the public consultation on the Labour Relations Bill 2015. I will be providing you with some background information on the process thus far. Minister Rivers will speak specifically to the Labour Relations Bill 2015 and the major changes being proposed. Mr. Ebanks will speak to the public consultation process and how the public can get involved in the process. The Labour Relations Bill 2015 aims to repeal the current Labour Law 2011 revision and the Employment Law 2004. The Labour Law 2011 revision was originally enacted in 1987. It has been amended on several occasions in order to address specific issues, creating the 1989, 93, 95, 99, 2000, 2006, and 2007 revisions. The most recent of these reviews was in 2010, when the law was amended in order to facilitate compliance with ILO Convention 182 on the worst forms of child labor, remove the 12 years of service caps in relation to severance pay, retirement/resignation allowance, and the remedy for unfair dismissal, and to remove the job placement functions from the department, with those functions now being carried out by the National Workforce Development Agency as part of the Ministry's realignment of pensions and labour. These changes resulted in the 2011 consolidated version. The last comprehensive review of the labour law was undertaken in the early part of the last decade, and this resulted in the Employment Law 2004. However, the commencement order was never issued to bring this law into force. The 2004 law was therefore reviewed by the Ministry and the DLP as part of the process to update the current labour legislation. Previous drafting instructions created by the Ministry during the previous administration were also reviewed and adopted where prudent. Further research was also conducted on labour legislation from other British overseas territories, including Bermuda and the Turks and Caicos Islands. Relevant provisions in Commonwealth countries such as Australia, the Republic of Ireland, and Northern Ireland were also reviewed. These reviews allowed us to see how our counterparts were dealing with their labour relations and whether anything they're doing could be adapted in our legislation to suit our needs. This extensive review has resulted in the new Labour Relations Bill 2015. Now that I've given you the background and the research conducted to develop the bill, I will hand over to Minister Rivers, who will go into more detail about the major changes enshrined and housed in the bill.
Thank you very much, Acting Chief Officer, and good morning, everyone. Good morning to the media for coming, and good morning to the listening and viewing public. As the Acting Chief Officer has outlined, the process that was undertaken to get us to this point was quite an extensive one. And certainly when we took office as a government, one of the first things, and I think you may recall one of the first statements that I made with respect to revisions to the labour regime would be forthcoming as a matter of priority for this government. So here we are, just under 2 years later, or just over 2 years later, and we have delivered on that commitment with respect to producing not just an amended version, which is reflective of the kind of tweaks that have happened throughout the past 3 decades, but looking at a comprehensive review of the labour regime and labour legislation in particular as it relates to the governing of labour relations in the country. So the ministry, the department, and the technical staff in the legal drafting department have really been working feverishly on producing this bill. And, unfortunately, as we all know, there are currently many labour issues faced in the country by both employers and employees in the Cayman Islands. And so it was the impetus or the urge of the ministry and the department, as well as other government entities, to hear cases of unfair treatment of Caymanians in the labour market, issues relating to businesses disregarding the current labour law, and employees suffering as a result of wrongful dismissals. And all similarly, the issues as it relates to frivolous and vexatious claims as well on the side of employers. So we do know that employees the overall employment rate of the country has dropped significantly since we took office, and most recently from 6.3% the overall rate in 2013 to 4.7% last year. And of course, the rate is slightly higher for Caymanians in that regard. This is still an area of concern for the government. And so through the efforts of this particular bill and other initiatives that the government has been undertaking, we are looking to address this concern. So again, as a result, this coalition government aims to address the issues and improve labor relations through the reform that we are currently undertaking, and starting with the foundation of the legislation, which we're here to discuss today. Because if we don't have an improved legislative framework, which is reflective of the current local situation, which takes into account the needs of employees and employers, and which aligns with international best practice, then essentially all other efforts to improve labor relations in the Cayman Islands will be largely fruitless. So again, we must also have a strong enforcement mechanism to assist with this reform process as well. And as Minister, I am pleased to say that I have received the government's support thus far to begin the redrafting of the labor law as a major step in relation to this labor reform process which we are undertaking as a country. And so throughout this process, it was determined that substantial changes to the labor legislation was needed in order to address the government's concerns and also to address the multiple and multifaceted issues faced by the Department of Labor and Pensions, and formerly the Department of Employment Relations, which they've been grappling with for a number of years. And as a result, it was agreed that due to the amount of the amendments being proposed, that it was proper to repeal and rename the labor law of 2011 with the objective of bringing forward a new piece of legislation. And this is what we have in front of us today with respect to the Labor Relations Bill 2015, which would, as the Acting Chief Officer said, repeal the current labor law once it has been adopted and enacted. Similarly, given that the employment law was never fully brought into force, and some aspects of that law have actually now been incorporated into the Labor Relations Bill 2015, the Department of Legislative Drafting advised the government that it would be appropriate time to repeal that law as well. So in addition to repealing the other pieces of labor legislation, which I've just outlined, the Labor Relations Bill 2015 seeks to reorganize labor and related operational procedures to benefit both employees and employers in the Cayman Islands. Generally speaking, the purpose of the amendments is to align the Labor Relations Bill 2015 with the coalition government's vision as it relates to our awareness of best human resources practices. The vision or the goal is to clarify the law for the benefit of all users, employees and employers alike, and other stakeholders, as well as to protect and enhance the rights of employees and employers where prudent. It's also to establish clear expectations in dispute resolution, as well as timelines for enforcement of action. This was an area which we felt was in need of addressing in the legislation. And so the bill looks to institute a more effective deterrent to non-compliance with the legislation by increasing penalties and fees where appropriate, and to ensure that efforts are made to lessen the opportunities for loopholes for structural discrimination against Caymanian employees. It is important to note that the Labor Relations Bill 2015 uses the current labor law as the base law. So the amendments that we will be discussing as it relates to the enhancements or clarifications made in relation to the current law, as well as discussing new provisions introduced in the bill as compared to what currently exists. So the following are some of the key policy changes reflected in the major amendments within the Labor Relations Bill 2015 as they relate to matters which already are contained in the Labor Law 2011 revision. The Labor Relations Bill recommends the removal of churches and charitable organizations as being exempt from the labor legislation. And the reason and the decision taken in this regard was to create equity in the treatment and working conditions of all private sector employees, irrespective of the organization of which such employee works. The Labor Relations Bill looks to improve the definition of an employee to remove ambiguity as it relates to various categories of workers not covered by the law. So, for example, full-time students, temporary workers, and volunteer workers would not be covered under the law. And it also includes the removal of the definition, the current definition that exists of casual employee, and instead creates a new self-employed casual worker definition, which means that the person who is engaged in an irregular or intermittent basis, such as, the engagement being on a short-term basis with a maximum of 15 hours per week for a period of no more than 90 days of service with any single employer. That is the more kind of concise definition of what a casual worker would be, or self-employed casual worker. Again, it was important to address this particular definition because this is an area that the Department of Labor and Pensions found was being abused. And so some employers were hiring and paying workers as employees, but impose self-employed or contractor conditions on them, which adds to the workers' expenses. So some of the employers, again, were also abusing the present definition by calling some persons casual employees for the long periods of time, but not extending the normal benefits to them because of the state that they were as a contractor, as being considered a contractor. So this was an area of definitional ambiguity that was causing a lot of problems with respect to labor relations in this particular area for employers that were using that particular ambiguity to the benefit of the employer, but to the detriment, of course, to the employee. So we felt it was necessary to deal with that issue in the law in this case. The bill also clarifies the definition of a part-time employee as being someone who's contracted to work between 15 to 30 hours per week. The bill proposes to require all employers to enter into a written contract of employment within 10 working days of every employee, including household employees, which will be a statement of employment conditions. And it does impose offenses as it relates to the failure to do such. The bill also requires requires all employers, regardless of size, to keep accurate work accounts for all employees with respect to the time worked, leave taken, and deductions, etc. And that there would be a requirement to produce such statement of wages. And again, there is a penalty regime which is incorporated in the event that the employer does not keep the accurate work account for each employee or fails to furnish the employee with a statement of wages upon request. And so, again, the requirement to keep work accounts previously applied only to employers with 10 or more employees. However, this amendment was deemed necessary by the Department of Labor and Pensions primarily to prevent the abuse of vulnerable employees, such as household employees who are often subject to unreasonable tasks and wages which are totally inadequate. The change to this provision is also a move to protect the rights of vulnerable workers in line with the ILO Convention number 189 concerning the decent work for domestic workers. Additionally, this section deals with many disputes and complaints and helps to address a concern or the reality that the origin of these disputes are often as a result of the absence of the preventative measure, which would be to have these statement of working conditions or contract. And, the best practice of having employment contract or work accounts, had this been in place previously, a number of complaints that the department is facing would not necessarily be the case because this would have been a preventative measure in that regard. And so by making it a requirement for all employees to have contracts or work accounts, this could potentially reduce the level of misunderstandings that currently exist and the grievances in the workplaces, and in turn, it would hopefully reduce the volume of complaints coming out or coming to the Department of Labor and Pensions. And again, additionally, the bill does provide a penalty regime which deals with persons or employers who enter into employment agreements contrary to provisions in the bill regarding the form of payments, deductions, and payment of wages, etc. The bill also deals with the issue of severance and severance pay. And what is recommended in the bill is to pay to move or to change the basic severance pay from 1 week per year completed to 2 weeks per year on a prorated basis up to a maximum of 24 weeks' wages as the employee's highest basic wage or at the employee's highest basic wage. Again, and in the case of unfair dismissal, the compensation rate of severance is 4 weeks' wages for each completed year up to a maximum of 48 weeks at the employee's highest basic wage. So that would be in play once there is the determination of unfair dismissal having been made. With respect to the compensation otherwise as it relates to unfair dismissal, the bill proposes that the 1 week per completed year of service is amended to reflect or to state no less than 4 weeks per year prorated with no cap, and also provides additional circumstances for the Labour Tribunal to consider when making an award for unfair dismissal. Again, this is just in the area where unfair dismissal is considered. So with respect to these increasing fees, it doesn't become an issue for the wider employer population if there isn't any issues or determination of unfair dismissal in this regard. The bill deals with the expansion of the requirements as it relates to health, safety, and the welfare of employees, as well as for the requirement to report accidents, injuries, and diseases to the Department of Labour and Pension. And it also puts a positive obligation or duty on employees themselves to protect their health, safety, and welfare. The Labour Relations Bill also deals with the issue of maternity leave, and it is recommending that the 12 weeks of maternity leave is increased to 14 weeks, again, in order to meet the International Labour Organization's minimum standards, and specifies that 6 weeks of maternity leave must be taken immediately after childbirth, and that is to ensure that the real purpose of maternity leave is being carried out, which is to allow that bond and caregiving for newborn children. While the bill still requires requires the employer to pay an employee for every hour of work in excess of the standard work week or standard work day, the bill removes the ability for employers and non-managerial employees to enter into agreements that no overtime will be paid for extra hours work. However, the bill does allow for employees to be able to work more hours than the standard work day, up to 4 hours, that is, on the condition that the total number of hours worked for the work week doesn't exceed the standard work week of 45 hours. And any agreement made in relation to overtime shall be approved by either a Labour Tribunal or the Director of Labour, and the employee shall receive either time off or time in lieu, as it's commonly known, equivalent to the extra hours of overtime pay, or non-cash compensation that is equal in value to or in excess of the value of the overtime due. And it was important that this section be included, and it reflects the fact that in reality, the negotiating power between the employer and the non-managerial employees, oftentimes there is a real imbalance in that. And so this was an area that the department felt very strongly about with respect to trying to address certain abuses that they were seeing with respect to this particular area. And so there is an actual offense regime that applies to this section as well in the event that this area of the law, if it is adopted as law, if it's not followed in that regard. But it is important to point out that the bill does retain the ability of employees at the professional level or managerial level or above to contract out of payment of overtime. And again, that reflects the understanding and in most cases the reality that the negotiating power of those employees and the employer is much more equal in that regard. The bill provides a clearer understanding as to when employees can file a complaint directly to the department or to the director of the Department of Labour and Pensions for resolution. And it outlines this complaint procedure as well as the possible outcomes when filing a complaint with the Director of the Department of Labor and Pensions. Again, this was deemed to be an important revision because it is an effort to prevent frivolous, vexatious, or no-gain complaints from being referred to the Labour Tribunal, which, of course, has costs associated with it in that regard. And with these amendments, there will be greater incentive and opportunity to engage in mediation and conciliation. And so the department will be able to assist in that regard and will reduce the current burden on the Labour Tribunal as well. The bill provides that any person who refuses to comply with the decision of the Labour Tribunal commits an offence, and again is liable as long as such refusal exists. They are liable to a penalty regime as well. And it does specify in this particular bill that any award made by the Labour Tribunal when registered in the Grand Court is enforceable as an order of that court. Again, it is a way to address an issue with respect to efficiency of people either being awarded pursuant to the tribunal, actually accessing justice, so to speak, depending on whatever that award was. So in addition to the expansion or the clarifications of the previously existing provisions in the labour law, which I've just outlined, the following provisions which I'm about to discuss are some major new provisions contained within the Labour Relations Bill, and they are not currently contained in the labour law as it stands today. So the Labour Bill discusses the issue of an established age of retirement with employees within employment contracts to be no sooner than 65 years of age, except where professional or other industry standards mandate an earlier age. And it also establishes a new penalty regime for non-compliance with this section as well. And again, this revision was seen as being necessary as a result of the trend that the department is seeing, where Caymanians in particular and some non-Caymanians are being retired as soon as they reach the age of 60, which is the current age in which a person is allowed to obtain the pensions under the pension regime. And so, whereas, these retirements are often being done without the employee being aware of any such established retirement age of the organization. And, such employees are often willing, able, and need to continue to work beyond the age of 60. And so just to say that a corresponding change with respect to the age of normal pension entitlement will be made in the pensions bill as well to reflect this. The bill also establishes, for the first time in law with respect to private sector labor relations, male employees' ability to access paternity leave within, specified eligibility rules. Males are eligible for paternity leave under the law, and they're also eligible for paid adoption leave. And again, that regime is outlined in the current labor relations bill. And this is an issue which, will provide, as I said, male employees with paternity leave, and that has been discussed, I think, for over a decade now, and it's actually a provision that was reflected in the employment law of 2004, but it also was most recently reinforced in the 2014 National Conference on Women and Girls, which the Ministry of Education, Employment and Gender Affairs hosted in March of 2014. And again, it is a provision that is reflected in the National Policy on Gender Equality and Equity. And so we felt that in bringing our labor legislation in line, we were trying to address whatever gender inequalities exist in that regard. The Labor Relations Bill also now specifically entitles pregnant female employees who meet the eligibility rules to take paid time off during their working hours in order to attend required appointments for antenatal care. And again, this is a regime that is outlined in terms of what those eligibility requirements are and what the requirements to actually be able to claim such time off entails. But again, this was felt as important as a result of the outcomes and the conversations and the recommendations of the 2014 National Conference on Women and Girls, which I hosted as Minister of Gender Affairs back in March of 2014, as I said. The bill requires that a fixed term contract have a start and end date, and that any subsequent contracts entered into with less than 30 calendar days in between such contracts shall be considered or shall be deemed continuous employment. And this was felt as being necessary because the amendment removes the loophole that some employers were using to engage in the abusive practice of rolling fixed-term contracts for the purpose of avoiding to pay benefits, including severance pay, to their employees. The bill also introduces a requirement for employers with 5 or more full-time employees to report in the prescribed form to the Director of the Department of Labour and Pensions in cases where specified employee redundancies and terminations occur. And in the report to the Director, it is required that for a period of time after such terminations take place, so for every 6-month period up to 24 months after such terminations take place, reporting mechanism is required with respect to reporting to the department or to the director as well, as may be specified by the director. And again, an employer who fails to provide these reports would be liable to a fine that is specified in the law. And it was important to address this amendment in the law because the department was seeing situations where employees, and in this case mainly Caymanian employees, are being made redundant, but then the employer will then hire a work permit holder for the same position. It does also give, I think, some clarity to the regime that is supposed to be in place now with respect to, hiring non-Caymanian employees where there is none or no Caymanian employees available to do the job. And so this was an area that, although there was a section in the law that talked about redundancies, there was nothing that really made that section operative. And so it was important that we actually addressed it in this way. And so the section of the bill also speaks specifically to where employers seek to replace a work permit holder with a Caymanian or a permanent resident holder. They would not be liable to pay severance or unfair dismissal compensation to the work permit holder who's replaced. And additionally, the bill provides that preference be given to Caymanians in hiring shall not be regarded as discriminatory. Again, this was due to the fact that, permit holders are given fixed term contracts with respect to the permit. And so the idea of, replacing an employee with a Caymanian employee is not deemed to be contrary to the law, because the fact is that the work permit regime should work in that where a suitably qualified Caymanian is not available to do the job, then those employees would be deemed necessary. So this is in an attempt to address a particular anomaly that was being promulgated in some instances as well. The bill also provides employees with protection from victimization or discrimination as a result of whistleblowing. So there are whistleblowing provisions in the proposed bill, and for those who make legitimate complaints to the Department of Labour and Pensions for specified situations in the bill, such as working conditions, etc. The Labour Relations Bill 2015 also introduces the concept or the definition of constructive dismissal. And this is an area that may be used also as a grounds for unfair dismissal. And so the proposed definition is circumstances in which the employer does not expressly dismiss an employee, but creates or allows the creation of a continuation of circumstances in the workplace that would make it impracticable for a reasonable person to remain in employment. Now, this is a regime that there's currently not covered under the law, but it is something that would have to be adjudicated in the courts and doesn't fall within the realm of the labor tribunals. The law or the bill also proposes that there be reasonable training for offered to employees during the probationary period in order to ensure that the employee is given the opportunity to be able to perform the duties in that regard. And it also provides for the possibility of termination during this probation to be considered unfair dismissal under certain prescribed circumstances. And the bill goes on to recommend and introduce an amendment regarding discriminating against Caymanian job applicants for being overqualified. Again, this was an indirect attempt to address a number of issues that the department was seeing with respect to people not being given the job because of the explanation of them being overqualified. And so basically what the bill seeks to do is to specify that Caymanians that have qualifications in excess of what is required, this shall not be or shall not make the person ineligible for hire for any particular position. So again, this is an area that is being proposed in the bill, and of course, will hopefully address some of the concerns that Caymanians have been complaining about in this regard. The bill also introduces a new amendment under discrimination, which prohibits employers from engaging in, permitting, or condoning sexual or other kinds of harassment of employees at the workplace or in the course of carrying out their duties. The bill introduces the ability of Cabinet to make regulations for administrative penalties, similar to what the Immigration Department uses currently, that will enable the Director of the Department of Labour and Pensions to administer where offences were committed under the Labour Relations Law. And additionally, the bill provides that the Director, the Deputy Director, and Labour inspectors will have, when performing the duties as it relates to the administrative penalty regime, they will have the same powers conferred on them as a constable under the police law and enter into workplaces to ascertain compliance with the law, etc. And again, this is in line with the number of the administrative penalty regimes that have been adopted by the government recently with respect to changes to various legislation in this regard. It does provide also for an increase in penalties with the introduction of new penalties for occupational health and safety breaches and the regularization of unpaid wages remediation by the courts. The law also, or I should say the bill also would require that every employer provide for the benefit of each employee's worker compensation insurance covering employees, or alternatively have approval from the Director of the Department of Labour and Pensions to provide bonding against the possibility of employee injuries or accidents. And it is important to, again, note that this provision was deemed to be necessary as a result of the department's own analysis with respect to the issues as it relates to occupational safety and health, the trends that they were seeing, and the enforcement challenges that they were having. But it also aligns with the recommendations of the Office of the Complaint Commissioner's own motion investigation report into safety in the construction industry. And again, there have been calls for widespread improvements in the occupational safety and health legislation and regulations as a result. And so this provision, or the provisions dealing with occupational safety and health in the proposed Labour Relations Bill, does address these concerns. And again, the employers, it does include a penalty regime that's associated with employers that commit these offenses and that continue to do so on the daily basis. The bill requires the Director of the Department of Labour and Pensions to take all necessary measures to enforce compliance of health, safety, and welfare section of the law. So it is a positive obligation on the department to ensure enforcement in this regard. And the bill also allows for Cabinet to make regulations prescribing a number of things, including regulations as it relates to safety measures to be taken in respect of machinery, prohibiting the use of any substance, the confirmation of any certification that supports the competency of any person to operate various equipment used in the construction or industrial workplaces, and regulations prescribing arrangements for the licensing, training, or certification by the Director of Labour and Pensions of site safety supervisors, occupational health and safety trainers, or temporary workers entering the islands for the purposes of conducting training. Again, the purpose is to strengthen the occupational safety and health regime that does not currently exist, but will hopefully exist as a result of the adoption of the bill. The bill introduces a statute of limitations with respect to when matters can be brought forward, which currently the bill is silent on. So the bill introduces a statute of limitations of 2 years in which the department can institute criminal proceedings for any offence under the law, and that the start date of such proceedings would be 2 years from the date in which the Department of Labour and Pensions receives a formal complaint from an employee or discovers the violation as a result of an investigation or a proactive inspection on an employer's records. Currently, the Department of Labour and Pensions is constrained by the 6-month statute of limitations in Section 78 of the Criminal Procedure Code because the labour law is silent on this point. And so by actually introducing a statute of limitations provision, this will hopefully reduce the possibility of cases being thrown out of court due to being past the current 6-month statute of limitations, which is currently being applied as a default period. The bill also requires a copy of the law, including any forms or regulations associated with the law, or and the contact details of the Department of Labour and Pensions to be made readily available at the workplace and accessible to all employees. And it also imposes a penalty as a result of any employer failure to make the information accessible to the employee. And finally, in an effort to ensure that, as we touched on in some of the provisions specifically, but more generally with respect to the law, in an effort to mainstream gender and gender issues throughout the bill, the ministry has looked at the bill with respect to the language. And so the bill and the language in the bill is gender neutral and or gender inclusive with respect to the way it is drafted. Again, this reflects that of the Constitution and the way the Constitution is drafted, but it also reflects our intention to ensure that gender issues are considered not just in substance, but in form when we talk about the drafting of the bill. And that is something that the entire Cabinet has agreed to do with respect to bills going forward or any revisions to the legislation. I made a specific request, and I'm very happy to report that the Cabinet has agreed to ensure that they look at any revisions to laws with a gender lens in that regard. I want to touch briefly on a question that I'm sure may come from the floor, so I'll just head it off right off the bat, and that is to do with the minimum wage and the regime as it relates to minimum wage. And as you would know, that those provisions are actually contained in the Minimum Wage Advisory Committee's report. So, and that report has been accepted by the government. So the actual provisions that would be needed to operationalize the regime is outlined. But due to time constraints of getting this bill out in a timely manner to be able to have such a public consultation and to enable changes to be made to the bill, if necessary, to bring it forward in the coming legislative cycle in the fall, we did not actually incorporate those specific provisions in the draft bill that you have, or that you will see as it relates to the Labour Relations Bill. However, the intention is that during this period of public consultation, the bill will be revised to include those sections, those provisions. But again, those provisions are already in the public domain, so people can refer to the report if you want to see the extent of the changes to the legislation as recommended in the Minimum Wage Advisory Committee report with respect to particular legislative changes that would be needed in order to operationalize. But what we do intend to do is to have discussions about the changes reflected in the draft consultation bill, but also the changes as would be reflected in the Minimum Wage Advisory Committee report. So the public consultation stakeholder meetings that we intend to have with the targeted stakeholders, as well as the public consultation meetings, which the director will speak to in more detail, will also cover the issues of both sets of legislative changes, if that makes sense. So you won't actually see the legislative changes reflected in the consultation draft being put out for consultation currently, but those changes you can see by referring to the Minimum Wage Advisory Committee report. And again, it's because we've had, as you would have heard now, the extensive changes being proposed in the consultation draft. We wanted to get this out to the public as soon as possible in order to be able to have a discussion about these other substantive changes, which we feel as a government and specifically as a ministry and the department that needs to happen in order to move our labor relations regime forward. So as you can see with the very extensive and detailed discussion that we've had this morning, there has been a tremendous amount of work that's been done in developing this bill. And I would like to take this opportunity to publicly thank my government colleagues for their support of myself as minister and the support that they've given me with respect to moving this process forward to this stage. And also, I want to thank the acting chief officer and the staff in the Ministry of Education, Employment and Gender Affairs, the director of the Department of Labour and Pensions, and also the staff of the Department of Labour and Pensions as well, for their contributions in making this extremely important process a reality. And of course, I would be remiss without thanking the staff of the legal drafting team for their hard work in getting us to this stage of actually having a consultation draft for public consultation, discussion, and debate. So with that, I would like to turn it over to Mr. Ebanks to take us through the process of public consultation for this bill.
Thank you, Minister Rivers. Good morning, everyone, and thanks very much for attending and for those who are listening and watching in the media. Given the substantive amendments that have been made, as the Minister has just outlined, and the critical nature of this piece of legislation, the Ministry of Education, Employment and Gender Affairs and the Department of Labour and Pensions will be launching a 60-day public consultation phase on the draft Labour Relations Bill. The draft bill will be released as a discussion document in order to allow the public and key stakeholders to become familiar with and to comment on the proposed changes to this important piece of legislation. From today, the bill will be available on the Ministry of Education website, which is www.education.gov.ky. And for direct access to the web page containing the draft bill, the public can also go to another website, www.education.gov.ky/labor pensions. It's important for you to understand that the spelling of labor is L-A-B-O-U-R, and pensions is also plural for that website. Once reviewed, the public can send their comments, and we encourage this, and also any concerns to the ministry by email, and the email address is lpl@gov.ky. Submissions must be received by the 31st of August this year, 2015. In order to assist the public in navigating the detailed piece of proposed legislation, there's also a helpful summary document available on the web page, which outlines the main changes being proposed in this bill. Other plans for public consultation include key stakeholder meetings and also public meetings in all the districts. Once finalized, the details for the public meetings will be released to the public via the various media outlets, and we thank you for your cooperation in that regard, and will also be posted to the web page containing the bill. The public meetings will take place in all districts, as I just said, including Sister Islands and particularly Cayman. The public consultation on the Labour Relations Bill 2015 will be done alongside of the public consultation on the proposed legislative changes within the National Pensions Amendment Bill 2015. which will be launched in a separate press conference on Monday, the 29th of June at 12 noon in this same location. All media are, of course, invited to attend that press conference as well. And to hear firsthand the proposed changes to another piece of legislation is very important, the National Pensions Law under the Pensions Bill. Given that these two bills will complement one another and have similar stakeholders, there may be overlapping public consultation exercises. However, there will be separate public meetings on the Labor Relations Bill starting in July, and public meetings concerning the Pensions Amendment Bill will commence in August. Additionally, we plan to have very simple opinion surveys available on these bills within the public during the next month. On behalf of the Ministry and the Department, I'd like to encourage all members of the public to read the Labor Relations Bill 2015 and to take part in the public consultation, as the proposed legislative changes will affect every single employer and every single employee in the Cayman Islands. Thank you very much, and now back to Acting Chief Officer, Mr. Suku.
Thank you, Mr. Eubanks. In closing, I would like to thank Mr. Eubanks for his years of service as Director of the Department of Labour and Pensions. He has been with us for 3.5 years. It has been a wonderful experience, and we have accomplished a great deal together under his leadership of the department. As most of you are aware, Mr. Eubanks has submitted his resignation and will be taking up employment at another agency. And I will leave it to him and that agency to make announcements in that regard in due course. However, for the time being, in order to finalize the public consultation exercise and in order for the director to finalize a few critical matters that he's been working on, he's agreed to remain in post as Director of Labour and Pensions on a part-time basis for a short period of time. After that, he will be vacating post permanently, and the ministry will commence the recruitment process shortly for his replacement. And I'm also glad and grateful to announce that Mr. Eubanks has agreed to take part in the recruitment process for his replacement, which would include serving on the recruitment panel and acting as a mentor of sorts and an advisor to the incoming director to ensure that we have continuity of operations and the department is able to grow from strength to strength. With that, I will open the floor for any questions that the media may have.
Morning, everybody. Wendy from Cayman News Service. Obvious question. A lot of new things in the law. Enforcement. That's the one thing that everybody complains about, which is we already have a law that isn't enforced. We've now got more things to enforce. What plans are in place to see that the law will be complied with?
Well, I'll start off speaking very generally, and I'll ask the director to kind of fill in some of the specifics that I may not be covering in my response. But as you would have seen, there is a number of changes to the law that deals with enforcement mechanisms itself. So there is a recommendation for a administrative regime which will greatly enhance enforcement ability with respect to timelines and timeliness of enforcement, etc. There's also provisions that actually spell out that certain things are now an offence, which didn't happen previously. So it was very difficult with respect to enforcement because the provisions themselves were vague as it relates to how that provision was supposed to be dealt with. Namely, for one example, the redundancy provision that currently exists does not really provide how that particular provision was supposed to be actually administered or adhered to. Now we've gotten a much more defined regime outlined in the consultation draft, so that those type of changes actually will enable enforcement to happen in a much better mannerism, because it actually specifies what is required in this regard. And also, finally, it's important to point out that this particular government, especially myself taking office as minister, and the government agreeing to increase the resources at the Department of Labour and Pensions. I would say that at the end of this particular recruitment cycle, which I'm not exactly sure where we are with that, somebody may be able to provide those details if necessary, we would have increased the staff complement since taking office in May 2013 to 9 persons. And so that is a significant investment in the department to ensure that the issues the legacy issues existing with respect to resources is actually being addressed proactively by, again, like I said, this government committing the funds in order to address those concerns. And I can tell you that with respect to the current budget, there is also additional staff budgeted with respect to increasing the staff complement, specifically as it relates to the issue of the minimum wage and what will be entailed in that regard. But also, the department has undergone a number of restructurings since we took office in May 2013 as well, looking, so there was two real issues of resources in terms of persons, but also the management of that resources and how you actually utilize and operationalize the resources available. So two things have happened in tandem since we took office. We've increased the numbers of people, and the department has actually restructured in the way it actually does its work. So hopefully that will help to, that coupled with the actual changes to the law that increases the ability to enforce, will address some of those concerns.
Can you just clarify that on the staff? You say during this recruitment cycle, you'll go to 9, and then you spoke about more staff. So are we talking about an increase beyond that 9?
I'll ask the director to speak specifically to that. But since taking office, there was an increase of 6 persons, and then there is three persons that were, as last I checked, or last I had been informed, there were 3 persons that were actually under recruitment currently.
Correct. Yes. Just to clarify or to confirm, we have 3 vacant positions at the moment: a senior labor officer, a labor officer, and an assistant labor and pensions officer. Those positions are all vacant, and we are actually at various stages of recruitment for those. We've interviewed, and one is the labor officer is supposed to start on the 30th of June. A senior labor officer has been interviewed, and hopefully by 1st of August. And similarly for the assistant labor and pensions officer. So those 3 persons are going to be assigned to the labor investigations unit. In addition to that, in the 2015-16 budget, there's an additional senior labor officer that's been approved by the Finance Committee and the Legislative Assembly for the department as well. As the Minister mentioned, since she took office in May 2013, for the department, there's been a total of 9 new posts. And we are continuously trying to develop and train, and as the Minister mentioned, establish standard operating procedures and timelines and checks and balances to ensure that matters are properly enforced, investigated within specific timelines. In addition to the other enforcement enhancements, the increased penalties in the Labour Relations Bill will also encourage employers to do the right thing, especially since it's been clarified what that right thing is in the Labour Relations Bill. We also are working to enhance our interagency cooperation with other agencies such as Immigration, Health Insurance Commission, and other regulatory agencies. The department is also having discussions with the Department of Public Prosecutions, where we've had challenges in terms of competing for scarce resources. And getting matters to the courts on a timely basis. And we're trying to develop a memorandum of understanding with the DPP in order to have some dedicated personnel to the department for labour and pension prosecutions, and a more defined line of sight in terms of our targets. I could also just say that what the Minister mentioned in the bill in regard to an order of the Labour Tribunal being regarded as the order of the court and enforced as such is also another important enhancement, because prior to that, at the present time, you have to go through an entire long process again to enforce an order of tribunal in court, whereas under this bill, it'll be a given that it's enforced.
Once it's filed with the courts.
Once it's filed with the courts. And finally, the 2-year statute of limitations is critical, because I know people in the public may regard 6 months as being sufficient. But by the time you start investigating and turn around twice, 6 months can be up, and you have to do your investigation properly to give the DPP a file that they can stand by to establish prima facie evidence. And without that, they will probably not send the matter forward. So the 2 years is an important enhancement and will help to ensure the department can enforce and can prosecute, but hopefully also educate and prevent at the same time.
questions, but let me just get the minimum wage thing out of the way. So just from a point of clarification, it's not as part of this bill right now, but once the consultation process starts, will we be bringing elements of that into the bill before it goes to the House?
Yes, I mean, essentially, it's not reflected in the current draft of the consultation draft of the labor relations bill that will be put on the website, or that is on the website again. And that was simply because of timing and the time that it would take to redraft and make those amendments. We didn't want to delay the process, given that those amendments are already in the public domain, so the people will know what those amendments will be, how they'll be reflected. What is going to take place is, during this period of public consultation, the redrafting of the bill will take place in order to ensure that it is reflected in the actual final bill that will be carried forward for legislative debate and adoption in the Legislative Assembly. So during the actual public consultation meetings, discussions will take place about both sets of amendments, so to speak, even though it's not wholly contained in the four corners of the draft bill that will be downloaded or available for review. Those amendments are available for review if you go to and refer to the Minimum Wage Advisory Committee report.
When are you hoping to bring this bill to the LA?
Well, like I said, the intention and the hope is that, during the legislative period, sometime this calendar year. That's certainly what the aspiration is from my perspective, and that's why we wanted to get the bill out for public consultation in enough time to be able to have the targeted stakeholder meetings with, of course, key stakeholders, but also having an ability to hear from the public at large, and then work in whatever amendments that may need to be made to the bill. And of course, it gives us an opportunity, because the changes that we've outlined is quite extensive, and we now will have an opportunity to look at the bill again and have one kind of final review to make sure that everything is hanging together the way that we expect it to do so. So that was the purpose of the kind of tripartite purpose of having a public consultation period in this way, is to hear from the public, is to hear from the key stakeholders, but also give the department and the ministry an opportunity to really go into the details of what's being proposed and see how the bill will work together as a whole.
You talked about being concerned by Caymanian unemployment, which I believe is hovering around 9% right now.
No, it's 7.9.
7.9%,
It's
so
dropped
8%.
from, if I'm not mistaken,
So
I think it's
8%.
hovering around just under 8%.
So specifically, what changes do you see in this bill that would seek to address that problem, making sure that Caymanians are getting jobs? Are there any specific?
Well, Tammy, I outlined a number of them, and now I'm going to have to.
And you think those will
here? But no, I think certainly the issue of not seeing, when work permit, the issue of not having to pay severance or these kind of things when it comes to when work permit terms come to an end. That, again, in some instances, employers were complaining that, there's really no incentive in that regard to actively seek Caymanians. But in this way, it does create an incentive for Caymanian employment. It also specifically specifies that when you seek Caymanian employment, it's not considered discriminatory. And again, this is in line with the Constitution as well, because the Constitution basically says, when in the area of employment and of movement of people in the country, that there is a carve out to ensure that we have and we address the issues as it relates to the local and domestic economy. And of course, employment of the local people is a critical factor in that regard. So there are a number of provisions, and I apologize. I don't know the details
just want to know
of it,
which
but
ones.
at this case, I'd have to look back to refresh my memory, but there are a number of provisions, that being one of them, the issue of severance, the issue of specifying that it's not discrimination to proactively seek Caymanian employment. Also, now it's coming back to me, the issue of the redundancies and making it very clear that there is a regime that needs to be followed, not just upon filing redundancies, but also a reporting regime subsequent to any such terminations or redundancies, to ensure that Caymanians aren't really being terminated and then work permit holders being hired to do the exact same position which existed previously. So those are the three kind of provisions I can think of.
And that's
but
what
I'm
I was
sure there are
after. Which
more.
ones you would link specifically to address
and
Caymanian
I'm sure there are
unemployment?
more, but as I said,
That's
the level of the extensiveness of the review, we certainly, that was one of the overarching, when I spoke previously about the overarching policy considerations driving the changes, that certainly was one of them, is to address the issue of Caymanian unemployment and the kind of structural discrimination that exists. And of course, constructive dismissal is another one, and the issue of Caymanians being considered to be overqualified for positions. So there are quite a few provisions in the law that addresses the issue of Caymanian unemployment and what we as a government are trying to do to address that problem from the legislative regime perspective.
Let me give somebody else a chance.
May I add one to that? No, one final one to that point that the minister mentioned. The other enhancement is in relation to probationary employees. That it is known that some employers may hire a Caymanian, and the law provides that the Caymanian has to be given, or the new employee has to be given training and development during the probation period. But they hire the Caymanian and they don't provide that, but they may have an idea to have a permit in the wings for somebody else, and 6 weeks or 7 weeks go by and they say, look, you're not working out, this is your last day, and then the next day they submit their work permit application. That happens, and the amendment to the Labor Relation Bill proposal will also assist with that in terms of the minister's quest to help with Caymanian employment and longevity.
Thank you, Director. I knew there was one other one that I couldn't think of it, but I think that hopefully gives you a good picture of the kinds of considerations that we've had and that we're actually reflecting in the bill as it relates to addressing the issue of unemployment amongst Caymanians.
Just a few housekeeping questions. Did you guys set a date for how long the paternity leave might be for?
Yes, and I think it's 5 days paid and 5 days unpaid for paternity leave, and then 1 week paid for adoption leave for male employees.
Very cool. And just to double check, so the new provision will include sexual harassment protection.
Yes, there's there's a section that talks about, but basically prohibits employers from either engaging in, permitting, or allowing sexual harassment or other forms of kind of discrimination on the job or at the workplace.
Are there other legislative pieces in place right now that address that, or will this be the first time that we have something in legislative framework that?
We do have a gender equality law, and I can ask the technical officer who is very much versed with that particular law that might be able to answer that question.
We can talk about that after. I don't want to slow it down. Okay, cool. So this one is just specifically for the workplace.
Yeah, it just tying in the expansion of what is prohibited at the workplace or on the duties of the job.
Right.
within
And
this regime.
constructive dismissal is making an environment so bad that someone quits, right?
Essentially, yes. Yes.
All right, cool.
Yes.
And then for the work permit holders being replaced by Caymanians, there would be no severance pay in that respect. But say, for instance, they were replaced by another work permit holder, they would still be eligible for severance.
Director, you want to address that?
Yes, the proposal is in respect to the employer replacing the work permit holder with a Caymanian. Of course, there's also some rules in terms of that as well to make sure it's valid, and that's outlined in the bill very clearly. But it's only in respect to Caymanians. That is that employer will not have to pay severance for the non-Caymanian who is replaced by a Caymanian. Read the bill.
Yeah.
And just to clarify on that one, Carsley, it should be pointed out that the way that the regime works currently actually acts as a disincentive to hire a Caymanian to replace a work permit holder. So this is to allow employers that flexibility to put Caymanians into the job.
Ralph Lewis, Cayman Weekly. I have 3 questions. The first one is for Mr. Ebanks. Notwithstanding that the bill is long overdue, do you foresee an increase in operational cost for business owners when this bill comes into play?
That's a very good question, Ralph. I know you asked me for, but those employers who do the right thing and who follow the law and who are employers of choice and who reach out to the department and attend training and get advice in terms of what they should do, have nothing to fear with the current labor law or the labor relations bill. So my advice to all employers is follow the golden rule. Treat your employees as you want them to treat you, and you have no worry about increased costs or penalties or fines. But those employers who ignore the law, then they have to fear. But we're going to continue the training and the outreach and the awareness. And I think that we're going to have a much more productive workplace, a much more tranquil workplace, a stronger economy, and hopefully less prosecution, less fees, less fines, but people focusing on profitability and productivity.
Thank you. And the second question for the minister: do you have a projected date for the implementation of this bill once it's?
Well, I mean, the government and the country has signaled that, the minimum wage regime will come into effect in March of next year. So obviously the goal and the aspiration would be that the bill would be, in force in its totality by then. But again, we do have to go through the legislative process. It's not just up to me as minister. I do need to get, of course, the final buy-in of the entire government. And of course, then when we go down to the House, it would need to be voted on, approved, and enacted. So what certainly, as minister with constitutional responsibility for this particular law and for bringing this law to the forefront now, as you said, it's long overdue. We've been working very hard to get it to this point. I will certainly do all I can to see that we get it to a stage where we do have a law that is not just passed, but also enacted as well.
And the final question is a short one from Mrs. Saku. Mr. Banks is moving on very soon. She's going to do some part-time. Recruiting process is going to go into place. It might take some time. Is there an acting position? Is there someone in the department that will be acting while this process is taking place?
While Mr. Eubanks remains in post, he will continue to remain as a director. Once he vacates post, then I will have an acting director put in place. I'm not at the point of announcing that quite yet, but as soon as I am, which will probably be within the next 2 weeks, then I will make a public announcement.
Thank you.
Hi, Charles Duncan with the Compass. Can you just clarify a little bit kind of the changes for household employees and kind of how, we saw a lot of interesting things out of the minimum wage report and kind of how that's informed how household employees are going to be treated now?
Well, without actually going through the provisions as it relates to the minimum wage, because I think we had a very extensive discussion about that when we launched the report. I would definitely refer you to the report to look at those particular provisions. There are some provisions in the current public consultation draft which deals with the household employers now being entitled to a statement of working conditions and contracts and the like. And I don't know if there's anything else that the director wants to add to that regard, but that's one of the primary changes, again, to ensure that there isn't the abuses that exist with respect to hiring somebody to do one thing and then they end up doing a million other things, and there's no real ability to either mediate or determine what really is the situation in that regard.
Yeah, nothing to add except that domestic employers, households, while they'll be expected to provide a statement of working conditions for their domestic workers, it need not be a 10-page legal contract. It can be a simple 2-page document that complies with the statement of working conditions in the law, and the department will also be available to assist with providing a simple template along those lines.
And yeah, thank you for that clarification. I was pretty sure that was the intention, but I would rather hear it coming from you, given that you're responsible for doing it. But certainly, we're trying to make the process as user-friendly and as accessible to all, including employers as well as employees. And as I said, this obviously the issue with respect to legal or law reform or the law relations process, we need to take into consideration the needs of both employees as well as employers, and this is certainly one way that we propose to do so, which is to help people, our employers, in this case, employers of domestics and household employees, the ability to access that help and that assistance.
And Mr. Ebanks, has enforcement and kind of figuring out where these abuses are, has that changed in your department at all over the past year or two?
It certainly has. Of course, we're like everybody else. We're bound by constraints and priorities, but we do have a separate inspections unit at the moment, and Mr. Gene Hides is heading up that unit. We have 3 units in the department, or three divisions. We have labor investigations, pension investigations, and inspections. And so the inspections unit right now is it comprised of the head of inspections and a senior labor and pension inspector, a labor and pension inspector, and an assistant labor and pension inspector. So we got 4 in that unit, or that division, to service the entire economy. So it takes a lot of being selective and being strategic. But what we do is target. Maybe target is not the right word, but we identify various sectors to do audits on a quarterly basis. In some cases more frequent, and we go there and we do, for example, the construction sector, real estate sector, the beauty salons and retail or whatever, and we go out there and do proactive inspections and audits. But also we go out based on intelligence and based on complaints, or based on referrals from the 2 other units, i.e. pensions or labor, and do unannounced inspections as we are allowed to do under the law. So I think with the ministry's support and endorsement, we have actually been more proactive, but we also have been doing more education and outreach and awareness to give people the tools that they need to do the right thing, as opposed to us coming in with a big stick.
And again, that goes back to what I said before about the kind of restructuring that has taken place in the department since we took office as a government. We looked very closely with working with the department to figure out how we can best utilize the resources. And so by establishing these various units within the department, the people are able to kind of focus on the various needs in that regard.
Any other questions?
If not.
No? If not, then we'll wrap it up. I thank you all for joining us, members of the media. I thank people of the Cayman Islands for joining us, whether listening or watching on television. Again, I'd like to reiterate and repeat the website, www.education.gov.ky/labor pensions. And labor is spelled LABOUR. If you log on, you can get access to the bill. We are encouraging public feedback as much as possible. This is a bill for the entire Cayman Islands, and so it's not set in stone. We are doing a public consultation exercise in order to elicit feedback so that we can have the best product go forward to the Legislative Assembly. Thank you all, and if you don't mind, at this one time, I'd like to beg your indulgence to say hello to my daughter Hannah, who's at home watching. Thank you. Have a good day.
Thank you all for coming.